Welcome to this episode of Term Talk, the Federal Judicial Center's video podcast program discussing this term's Supreme Court opinions that are likely to have the most impact on lower federal courts. I'm Jim Chance, Senior Judicial Education Attorney with the Federal Judicial Center in Washington. For about the next 15 minutes, we'll discuss two important civil rights cases. First, Medina versus Planned Parenthood, then Perttu versus Richards. I'm joined today by Erwin Chemerinsky, Dean, and Jesse H. Choper, Distinguished Professor of Law at University of California, Berkeley Law School, and Tara Grove, Professor and Vinson and Elkins Chair in Law at the University of Texas, Austin School of Law. It's great to see you both. Tara, Medina versus Planned Parenthood of South Carolina involves a suit brought under Section 1983 to enforce a provider of choice provision in the Affordable Care Act. Will you explain the issues in this case for our audience?
Sure. 42 U.S.C. Section 1983 is a statute that allows people to enforce federal rights against state officials, and local governments. We normally think about it as a statute that helps people enforce their constitutional rights, but it does say the Constitution and laws, and therefore allows people to enforce statutory rights as well. And one of the things the Supreme Court has faced over the years is whether that means all statutes or only some statutes. So in 1980, in a case called Maine versus Thibodeau, the Supreme Court faced this question and said, well, the text of 42 U.S.C. Section 1983 does not make any distinction among the laws that it allows people to enforce, and so it applies to all types of laws. And that was the governing regime for a long time. The Supreme Court struggled with how people would enforce their statutory rights under Section 1983. And in a case called Gonzaga versus Doe in 2002, the court said, okay, here's a two-part test that plaintiffs have to use in order to enforce their statutory rights under Section 1983. First, they have to show that the statute was actually meant to protect individual rights, so it needs to contain language about individuals or rights or words to that effect. And second, the plaintiff needs to show that nothing in the statute at issue forecloses a Section 1983 remedy. For example, if the statute itself allows private plaintiffs to sue through some other mechanism. So that's the test from Gonzaga versus Doe, a very, very difficult test to satisfy, and plaintiffs struggled with that for quite some time. And yet in 2023, the court, in a case called Talevsky, said that plaintiffs could enforce a statute. The statute actually satisfied the requirements of Gonzaga v. Doe. That was the Federal Nursing Home Reform Act. The court said that that statute does contain sufficient rights conferring language and does not preclude a Section 1983 action. This was important not only because it showed the Supreme Court saying people really can enforce statutory rights under Section 1983, but also because it involved a statute enacted pursuant to the Spending Clause. In that case, the defendant alleged that it was not possible to enforce a Spending Clause statute under Section 1983. What they said was Spending Clause legislation is different. When Congress enacts Spending Clause legislation, it's creating more of a contract and not so much of a statutory right. And the court in Talevsky rejected that and said if you look back at the language of 42 U.S.C. Section 1983 itself, it applies to all laws, including spending laws. And that leads us into this case.
All right, Erwin, tell us about the facts in Medina.
This case involves the Medicaid law. Medicaid, of course, is a federal program. No state has to participate in Medicaid. If it takes federal Medicaid money, it has to meet the conditions of the Medicaid statute. One of the conditions is that individuals can have the provider of choice, the doctor that they want. South Carolina adopted a law that said Planned Parenthood in that state could not receive Medicaid funds. Now, to be clear, this wasn't about abortion. Already there's federal and state laws that would prohibit Medicaid funds for using abortions. This involved whether a woman could go to Planned Parenthood for other medical services. And because of the South Carolina law, she couldn't. So she sues and says, I'm bringing a suit under Section 1983 to enforce this provision of federal law that says I should be able to have my provider of choice. South Carolina is violating that. I should be able to get a remedy.
Erwin, talk to us about the reasoning.
The issue is exactly as Tara says. When can you use 1983 to enforce a law adopted under the spending power? Gonzaga v. Doe says it has to be a law that creates a right. And here the Supreme Court, in an opinion by Justice Gorsuch, says that this statute doesn't create a right. Why not? Well, the court says that it has to be regarded as a rare circumstance where a spending clause statute creates a right, that the language has to be unequivocal in doing so, and that this statute, in saying that individuals can choose the medical provider of choice, wasn't sufficiently clear and specific. Justice Gorsuch invokes separation of powers and says when Congress wants to create a right, it knows how to do so. He says the presumption is that spending clause legislation is enforced by cutting off money if the recipient doesn't meet the conditions, not by having lawsuits. And he compares the language in Talevsky, which Tara was talking about, to the language of this statute. The bottom line is the court says we're still going to allow lawsuits under 1983 to enforce spending clause legislation, but only in relatively rare circumstances.
So Tara, Justice Jackson wrote a dissent, joined by Justice Sotomayor and Kagan. Can you explain their analysis, please?
So Justice Jackson said, if you look at the language of the Medicaid Act, which says that people can choose any qualified provider to serve them, that would seem to give individuals a right to choose their doctor. And she said this is no less clear than the language in Talevsky from just 2 years ago. And Justice Jackson's dissent also expressed concern about broader trends in the U.S. Supreme Court in terms of its openness to lawsuits under Section 1983.
What are the implications for the lower courts in this opinion?
I think this is a very important case for the lower courts for just the reason that both of us have been saying. There are so many laws adopted under the spending clause that create requirements for recipients. And the question is, when can somebody bring a 1983 suit against a local government or state or local officer to enforce those? The Supreme Court didn't say never, and I think that's important. That's where Justice Thomas clearly wants to go. But the court says it has to be language that is clear in creating a right in order for there to be a 1983 suit.
Okay. I'd like to quickly cover one other case for the lower courts, Perttu versus Richards. Erwin, what is this case about and why is it important?
It's about the exhaustion requirement under the Prison Litigation Reform Act. And whereas generally there's no requirement for exhaustion to bring a 1983 suit, the PLRA very much creates such an exhaustion requirement. Here what you have is a prisoner who claims that he and other inmates were sexually harassed by a guard. He said he didn't exhaust his remedies because the guard threatened his life had he done so. He didn't exhaust his remedies because the guard had destroyed key documents that he needed to do so. And he went to federal court. The magistrate judge held a hearing, and the magistrate judge ruled against the inmate and said that he should have exhausted the administrative remedies. And it went to the Supreme Court. And it's interesting, the Supreme Court granted certiorari on the question of whether it violated the Seventh Amendment right to jury trial to have the magistrate judge hold the hearing rather than go to a jury. The Supreme Court didn't decide the question cert was granted on. Instead, an opinion by Chief Justice Roberts said, in a situation like this, where the reasons for not exhausting are so tied to the underlying claim, that then, under those circumstances, the PLRA should be interpreted as requiring a jury trial.
Tara, why is this holding important?
So I think it's hard to say how this holding is going to apply in a lot of other contexts. Even in the context of the PLRA, there are not going to be a lot of exhaustion claims that are necessarily tied up with the merits. I think a couple of things that are interesting about this case is it reflects continued interest on the part of some justices in the Seventh Amendment, because even though the court was not ruling on the Seventh Amendment, clearly it was considering the constitutional undertones of the Seventh Amendment and its requirement of a jury trial in construing the federal statute. And I think that's of a piece with other recent decisions where the court has tried to give a few more things to juries. I also think it's quite interesting, the lineup. Chief Justice Roberts wrote the opinion for the court, joined by Justice Gorsuch, Kagan, Sotomayor, and Jackson. And then Justice Barrett dissented with Justices Thomas, Alito, and Kavanaugh. And I mention that because people sometimes are surprised when the lineup does not go exactly as they would anticipate.
Erwin, Tara, thanks again for joining us. It's always a pleasure to have your insights.